This young lady you see here in the picture is Miss Korryn Gaines, age 23, with her son Cody. And on August the 1st, 2016, between the hours of 9:10 and 3:24 p.m., there was a 6-hour standoff in Baltimore County where she was killed by the SWAT team. On September 21st, the State's Attorney's Office decided not to file criminal charges against those officers. Today, February 16, 2018, a jury of 6 women awarded her son and family and estate approximately $37 million. $32 million will go to her son for future. I'll talk more about this in a few minutes. Hey guys, how you doing? This is Mike McCormick with Advanced Criminology here in Owings Mills, Maryland. And today's discussion will be the verdict of the Korryn Gaines hostage situation that occurred back August the 1st, 2016. Subsequently, on September 21st, the State's Attorney's Office in this particular case in Baltimore County decided not to file criminal charges against the SWAT team officers who had entered Ms. Gaines' apartment after they had seen that she had a shotgun pointing it at them. Today sends a powerful message, I'm sure, to the police department in the jury's mind that the officers in this case acted with malice in this particular case. So, having said that, and they found that the evidence presented by Ms. Gaines' attorney, the family's attorney, that evidence was worthy of judgment on behalf of the family for $37 million, to be exact. Now, I decided to report on this case because I was contacted by some of you out there who listen to this channel, and a few people, my friends, also just asked me would I, speak on this. And quite naturally, when I come to you guys, I come to you guys from a couple perspectives, as you know. I'm either going to come to you from a practitioner perspective or from an academic perspective. And oftentimes, I have to leave both aside and just play the jury, the layperson's perspective, because in this particular case, this wasn't a criminal case. This was a case that was going to be decided on the preponderance of evidence. And as you know, there's a lesser requirement of proof when we're dealing with civil cases, particularly these types of lawsuits. They're not held to the same type of legal standard that a criminal case would be held in. And so there's a lot more information for a jury to look at and to evaluate to make a decision. In the state of Maryland, a jury trial, when it comes to civil suits, you only have to have 6 people, as in normally a criminal trial you would have 12 for a jury. And you would have to have 3 alternates in this 6-member jury panel. In this particular case here, there was 6 women on the panel and 3 alternates. And again, they decided today, after almost 3 weeks of hearing testimony about this particular case against the Baltimore County Police Department, that in fact the officers should be held liable for the death of this young lady. And so again, they awarded her $37 million. So I wanted to talk briefly because a lot of things in this particular case, I had the opportunity to read some things in this case, and one thing that stood out for me is that there was a time where the defense counsel, not defense counsel, but the counsel for Ms. Gaines' estate had made mention that after she was initially shot in the apartment and she was no longer a threat and she hit the floor, that the leading officer in this case of the SWAT team, Officer Ruby, had fired 2 more rounds into her back, which I found quite disturbing because the threat had been neutralized on the first shot when she had hit the floor. So to stand over top of this woman and fire 2 rounds into her back, I've been on the police department for 10 years and I just couldn't see myself shooting a woman or any individual in the back after they've been neutralized. I mean, you could take this back to the Old West. Back in the day, it was unheard of. That was a sin to have a gunfight and shoot someone in the back. And in this case here, flash forward over 200 years, in this day and age, we still have some of this stuff going on, which tells me from a practitioner point of view that there's some training issues with the Baltimore County SWAT team that needs to be worked on. And so I'm sure we'll be hearing more about training in this area about that particular incident. This was an incident that started somewhere around 9:30 in the morning and then culminated later, like 3:30 in the afternoon, about 6 hours, which in my estimation, having looked at a lot of these different cases around the country when we talk about standoffs, was not a lot of time, particularly when the information was that this lady suffered from severe mental illness. Quite naturally, this isn't the same type of person that's a career criminal that's maybe having a bank robbery, and they're holding tellers and patrons hostage. So in my estimation, it seemed like to me that there'd be a little bit more time to work things out. And I guess the jury felt the same way based upon the case that was laid out through her state attorney. So I'm just, like I said, I wanted to address that particular thing because I just thought that was quite chilling to hear that an officer would continue to fire on a person after they were face down on the floor. So maybe that didn't come out in the news, but certainly I've read through some documents, okay, where the bullet traveled through her armpit, through her lungs, and it ricocheted off a refrigerator. And if you didn't know, it struck her son in the cheek. And that's probably another reason why you don't fire a weapon through a wall. Which, if you didn't know, this is what happened. This SWAT officer basically decided that the way to take her out would be to fire through a wall. Now, I don't know whether they teach that type of training in the Baltimore County Police Department, but certainly something I'll follow up on. I just can't see it being it's such a risky shot to take, particularly when you had a young person that was nearby that could have been killed as well. So, I'm sure they'll be looking into that, as time goes on. Excuse me. What I also wanted to discuss too was that during the trial, they had the commander of the SWAT team on. Now, for you guys who don't really know, lots of times, a lot of officers, police officers, actually don't really testify. Most cases, about 90% of them in the district court and federal court, are plea bargain cases where officers never really get on the stand to testify. So, quite naturally, a seasoned defense counsel or prosecutor can kind of really make way and make a case and trip a lot of officers up based upon their inexperience of testifying on the stand. And this is probably why it would account for about 10 to 15% of testimony by police officers, and this is nationally, is fabricated testimony. Because officers don't get the opportunity to testify as much. And so they'll pretty much say anything that makes their case. However, sharp defense counsels or prosecutors can see right through this, and this is why they always say, generally, lawyers already know the answers to the questions before they even ask. And if you're a person on a stand, quite naturally, you should know that. So you need to be prepared and prepare yourself for certain questioning in a case. So I just found that here, this gentleman is a commander. Quite naturally, he's been on the police department for some time, and yet he couldn't answer basic questions through defense counsel or her state counsel on the stand. And so, a lot of that certainly hurt their case, because if the head man who gave the order to kill this woman can't answer questions, basic questions, then certainly, what can his troops do? So I thought that was interesting. The officers gave, according to the Baltimore Sun, the officers gave inconsistent statements. Not only inconsistent statements, they gave pre-trial depositions that were used against them in this particular trial, where there was inconsistency, and then in their testimony. So at three junctures in this particular case, you had officers giving inconsistent statements at all three: pre-trial, during trial, in their testimony. And these are depositions, whether they're written or given on a tape. So certainly, again, I'm critical always of police officers when it comes to not being prepared. That's what you're getting paid for, to be prepared. This was not a case where I thought the police department in Baltimore County thought they were going to have a slam dunk case on their side, simply because the officers were not charged originally criminally in this case. So you can't just assume, and that's what they did. They assumed in this case that it would be a slam dunk, and quite naturally, juries are sharp. They can listen and hear things that make sense, and also they can, again, a lay jury can sit there and listen to things that don't make sense. And I'm sure a lot of things that these officers testified to just didn't make sense at the end of the day. And so the jury ruled in Mrs. Gaines' family's favor that the county should be held responsible for her daughter's death. There's a case called Tennessee versus Gardner. I reckon it's a Supreme Court case, and that kind of gives way to what an officer's role should be when it becomes the use of deadly force, and during the Fourth Amendment. So basically, her counsel, her family's counsel, attacked this case a couple of ways through constitutionality. They looked at the Fourth Amendment and they looked at the Eighth Amendment. You know, the Eighth Amendment basically says we all in America have a right to life, property, and the pursuit of happiness. And so, you know, when that becomes, when those things are not, when we're not able to have those things for whatever reason, whether it's law enforcement's infringement upon that, it has to be addressed in the court of law. And so the Eighth Amendment deals with also cruel and unusual punishment. Was it cruel and unusual after you shot a young lady and she fell and face down and you fired 2 more rounds into her back? Was that cruel and unusual punishment? I think that it was. That's just my opinion. You know, I look at some of the court opinions and how they reasoned about the Eighth Amendment, cruel and unusual punishment. And so that's the arguments that were made. They made procedural arguments in the way tactical units operate in when it comes to situations like this. For me, having read the case, I kind of think that more should have been done in the area with, you know, trying to talk her out, trying to talk her down. I don't think 6 hours is enough. I think, you know, you really can't even put a timetable on some of this stuff. It's a flow of how things are going during negotiations. If they break down, okay, you try again. If they break down, you keep trying again until you can kind of break through. And I just don't think 6 hours, particularly based upon the mental illness that this lady was suffering from. If you go back and read her Facebook pages, if you go back and just listen to her confrontations with police, they always sound as if she's a person that just is not coherent when she's speaking. Okay, and she's just rambling on in a rant, and so you know, I can look at that and see that she has severe mental problems, and I don't see why those officers on the scene who had this information didn't try to negotiate in a fashion and bring in professionals, whoever they had could bring in, and let this thing move a little slower and a little bit longer than what it had to be. The bottom line is this: I wasn't on the jury. I'm just a person here doing the Monday morning quarterbacking, and the jury felt as though that the officers, in fact, certainly did not follow all procedures, certainly violated her constitutional rights. A lot of folks out there may not like it. I've heard some of the opposition to this about law enforcement out there doing their job and how hard it is. It is a hard job, and this is why we only want the best of the best when we take law enforcement in. Because these are the things that will happen in any given moment while you're wearing a uniform out in the street. So we need to have people that can be dependable, people that can think on their feet, and people that understand that oftentimes everybody does not have to be shot down like a dog in the street. It just is not the way that it's done. And so if I can go through policing for 10 years, I pulled my weapon out one time, right, and shot somebody and missed, right, in 10 years, you know, I don't understand and why we have these situations over and over and over again where we have police out there that just aren't thinking things through, and they're shooting first and asking questions second. And I believe in policing 100%, but it has to be done in a methodical way, in a legal way. Simple as that. With that, I'm going to close this out. If you have any questions or concerns or comments you want to make, just give Mike you know how I do, just give me some comments down there and I'll respond back to you. This will be a textbook case. Trust me, when these incidents happen, particularly with a lawsuit of $37 million that Baltimore County will have to pay out, trust me, they will go back and look at this thing and play it over and over again, not only in the police academy, training academies here in the state of Maryland, but all over the country, okay? Because this sets a precedent. This case here will set a precedent for other cases around the country, that if this type of thing happens again, they can use this case to prove their own case, that the police department was in fact wrong. My name is Mike McCormick. I'm with Advanced Criminology here in Owings Mills, Maryland. I thank you for your time.